Welcome, everyone. This is the first of two videos on civil rights and liberties, also known as social movements and the struggle for equality. And the reason those go together is because our civil rights and liberties in large part have resulted from the efforts of social movements in our society, the civil rights movement, the feminist movement, and other social movements to expand our civil rights and liberties. And so the topics are very closely related, but we're really going to talk in depth about a certain type of public policy, which is our public policies related to civil rights and civil liberties. Now, I'm going to repeat myself a number of times in the course of these two presentations, and that is intentional because there are some key concepts here that I think need to be repeated, or people don't quite get them. So I hope you'll pardon me, but there will be a bit of repetition, and I hope it'll help you get the essential things that certainly we're going to be testing you on, and that, I think you need to know about as citizens. So first, this is the main topics that we're going to cover. We're going to talk about a quick overview that what do we mean by civil rights? What do we mean by civil liberties? And as you will see, they're not the same thing. And people often use the terms interchangeably, but they are not really the same. And I will probably use the terms interchangeably in at some point or another. But I want you to understand there's a difference between these two types of constitutional and legal claims. And sometimes actually they come in conflict. That is, one person is asserting a civil liberties claim and another person is asserting a civil rights claim, and they actually get into a conflict with each other. And I'll give you an example of that. We'll talk about the historical background here, which is, I think, critical to understanding this subject. You have to understand a bit about U.S. history. We'll talk a bit about the Bill of Rights, and key point, and this is one of the ones I'm going to repeat. Originally, the Bill of Rights limited only the national government, did not limit the states. But then when the 14th Amendment was passed after the Civil War, the 14th Amendment limited state governments. And so what happened over time is that the Supreme Court began to view the 14th Amendment due process clause as including or incorporating the guarantees that are in the Bill of Rights. And so eventually we ended up with the states having almost the same limitations with respect to civil liberties and civil rights that the federal government has. It's almost the same. And we call that process incorporation of the Bill of Rights into the due process clause of the 14th Amendment. And then we will talk about civil liberties, which are mainly found in the First Amendment and also the rights of property in the Fifth Amendment. And that will conclude this first video. The second one, we'll talk about civil rights, where we will focus mainly on the 14th Amendment, the Equal Protection Clause, and that is where you really see the important historical role of social movements. So this is kind of a diagram. This is the overview. So you see civil liberties are freedom from government. Civil rights are a claim on the government. So a civil liberties claim is to the government, leave me alone, I don't want you in my life. And a civil rights claim is, government, come help me. I have a problem with other individuals in society or another level of government. Again, I'm going to repeat that and I'm going to go over it in more detail, but that's the essential difference. And there's been a revolution, you might say, about civil liberties and a revolution on civil rights throughout our history. The biggest part of the civil liberties revolution was the incorporation of the Bill of Rights into the 14th Amendment due process clause, which took place over like 100 years. And the civil rights revolution really involves a lot of congressional legislation that was passed pursuant to Congress's power to enact and enforce the 14th Amendment Equal Protection Clause. So again, we're going to talk about each of those, but understand there are separate legal foundations for each of these two revolutions, one in civil liberties and one in civil rights. So let's go into this in a little bit of detail. A civil liberties claim. Liberty means freedom, right? Well, a civil liberties claim is one where you are claiming or asserting the right to be free from governmental interference or involvement in some area of your life. For example, freedom of speech. Are you asking for anything from the government? No. You're saying, government, leave me alone. I just want to speak. I want to be heard. Freedom of the press. Are they asking for anything from the government? No. They want the government to leave them alone so they can publish their newspapers or run their web page. Now, it's important to understand that we do not have civil liberties that protect us against the actions of other private individuals. For example, your employer. If you work for Microsoft or Amazon, you don't have any freedom of speech rights with respect to your employer. They can make you take your political cartoons down. They can do it. It's their workplace, and if you want to assert a civil liberties claim, there needs to be a government involved. So the civil liberties rights that we have in the Constitution, these civil liberties protect us against the actions of governments, not private individuals, not business corporations. So if Twitter shuts down your Twitter feed because they don't like the things you said, that's not a violation of your constitutional rights, because private corporations don't have to respect your constitutional rights. Your constitutional rights protect you against government and only government. So this is a very important thing that you need to keep in mind. There needs to be what we call state action to invoke a constitutional right claim. That some government has to be the one infringing on your civil liberties. Now, by contrast, a civil rights claim is different. A civil rights claim is actually a request for government involvement in your life. You are asking for their help. You are saying, I have a conflict with a lower level of government, like a city or state. Or I have a conflict with my employer. Or I have a conflict with some other private party, like a school that you tried to get into or something like that. These are discrimination claims. Civil rights claims often involve some form of discrimination. And when people feel they're being discriminated against, they don't need state action. You can be discriminated against by a private citizen, by a landlord, by a university, by an employer. And you go to government with a civil rights claim saying that discrimination was illegal and it violates laws, statutes that go back to the 14th Amendment, usually to the 14th Amendment Equal Protection Clause. Now, so there's the difference. The civil liberties claim, you're saying, government, leave me alone. A civil rights claim, you're saying, government, come help me. Now, these claims can actually conflict with each other. I'm going to give you an example where, for example, one private party says, I should be free to do something, hire and fire whoever I want, that sort of thing. And someone else says, no, you don't have the right to do that because I have civil rights. So the one person is claiming a liberty, the other person is claiming a right. And a Supreme Court case in 2018 you may have heard of involving the wedding cake. This is the Masterpiece Cake Shop versus the Colorado Civil Rights Commission case decided in 2018. Jack Phillips is a baker and a devout Christian. I'm reading basically what comes from the opinions. I didn't actually write this summary. I kind of adapted it from the synopsis of the opinion. In 2012, he told a same-sex couple that he would not bake a cake for their wedding celebration because he's opposed to same-sex marriages. And he said he would sell them, other baked goods if they wanted them, but he was not going to create a special customized cake for their gay wedding, their same-sex marriage. So the couple then filed a complaint with the Colorado Civil Rights Commission because they had an anti-discrimination statute which prohibits discrimination based on sexual orientation in any place of business engaged in any sales to the public. So what we have here is that Jack Phillips asserts a liberty, freedom of religion, First Amendment, liberty, right? That's the baker. But the same-sex couple, they assert that a civil rights statute that protects them as, in this case, a same-sex couple protects them against discrimination based on their sexual orientation. So you see, you have a civil liberty clashing against a civil right. The Supreme Court ruled in favor of the baker. They said that the commission's actions, the Colorado Civil Rights Commission's actions in saying that he had to make the cake or break the law, violated the Free Exercise Clause of the First Amendment, which says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Now, so there you have an example of the conflict. And here you can see the couple are on the left and the right, and the baker's in the middle in this picture. And so these are real people who had a real case that was put rights and liberties in conflict, and the Supreme Court decided in favor of the liberty, the religious liberty. They don't always, but they did in that case. Now, so that's an example so you understand the difference here. Now let's talk about the Bill of Rights. Let's talk, because we're mainly focusing right now on civil liberties, right? During the ratification debates over the Constitution, 1787, there was no Bill of Rights. And James Madison and others promised, basically, they said, look, to these ratification conventions around the states, if you ratify this Constitution, the first thing we're going to do when we get it to our first Congress under this new Constitution is we're going to pass a Bill of Rights, because there were concerns about that. And but interestingly, other people like Alexander Hamilton said, "Oh, we don't need that. We don't need a Bill of Rights, because the federal government can only do specifically what it's authorized to do, and it's not authorized to infringe on civil liberties." Well, that logic did not prevail. And in fact, when the first Congress convened, they immediately passed a Bill of Rights, the first basically 8 or 10, depending on how you count it, amendments to the U.S. Constitution. I mean, there are 10. That's the Bill of Rights. It's 10 amendments, but only 8 of them really lay out specific liberties that we're going to and rights that we're going to talk about. The other 2 we'll talk about as well, but pardon me. Now, the interesting wrinkle about this, as I said earlier, was that the Bill of Rights was originally intended only to limit the national government. Why? Well, that's the new government they were creating. The states had already existed. They already had their own constitutions. And the new government they were creating was the U.S. government in Washington, and which is where it is now. And this is what generated the fear. Everyone said, well, this is a new level of government. We have 13 governments. Now we're going to have a 14th. And the idea of the Bill of Rights was to create protections against this new level of government. So originally, it only limited the national government. And then in 1833 came this opinion, Barron versus Baltimore, where the Supreme Court made that exact ruling. They said, and I'll talk about this opinion a little bit later when we discuss the takings clause in the Fifth Amendment, but the Supreme Court ruled in Barron versus Baltimore, the Bill of Rights only limits the national government, and that was the original understanding. But that's not the way it is anymore. Now the Bill of Rights, almost all of it, also limits the state governments in almost exactly the same way. And this is because of the 14th Amendment, which was passed after the Civil War in 1868. And the whole point of the 14th Amendment was to limit the actions of state governments. That's why it was passed. Just like the Bill of Rights was originally intended to limit the national government, the 14th Amendment is absolutely intended to limit states. That's what it's for. It creates national citizenship, which you may seem, well, why didn't we already have that? No, we didn't. The argument made by the southern states was that you're only a citizen if a state says you're a citizen. And so the 14th Amendment created national citizenship and created specific rights of national citizenship that cannot be infringed by the states. And as you'll see, these are the 3 clauses. The first, it says all persons born or naturalized in the U.S. and subject to the jurisdiction of the U.S. government are citizens of the United States and of the state where they live. So it clarifies, if you're born or naturalized in the U.S., you are a U.S. citizen. And that thing about subject to the jurisdiction thereof was put in there to exclude the children of ambassadors from other countries who are born here. Because, if you're the French ambassador and you're living in Washington or New York, and you and your partner, your wife, have a child in the United States, and you're French, you don't want your children to be American, right? Because you're a French ambassador. And so they excluded people who are not subject to our jurisdiction. They have diplomatic immunity, and those people, their children are not granted a birthright citizenship. But everyone else born in the United States is a citizen automatically. It's called birthright citizenship. Everyone. Now, first, having said that we're all citizens, then they said, there are rights that go with national citizenship. No state, note the words, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the U.S., nor shall any state deprive any person of life, liberty, or property without due process of law. That is the due process clause. That is the all-important due process clause that becomes the vehicle for incorporating Bill of Rights provisions into application against the states. Why? Look at the word liberty. They can't deprive us, states can't deprive us of life, liberty, or property without due process of law. That is the due process clause. So in trying to figure out which liberties they have to respect, the Supreme Court said, well, let's look at the Bill of Rights. It must be those liberties. Those are the liberties of national citizenship, and so the states have to respect those. And then we have the next clause, nor shall states deny to any person the equal protection of the laws. That is the equal protection clause, which becomes the foundation for civil rights statutes. And note Section 5 of the 14th Amendment. The Congress shall have the power to enforce by appropriate legislation the provisions of this article. That is an additional grant of power to Congress in addition to what was in the original Constitution. And this is where civil rights statutes come from. They are grounded in Section 5 of the 14th Amendment, which is a specific power that was given to Congress by that amendment. Now, interestingly, if you look at the history of civil liberties decisions, I'm talking now about First Amendment, religious liberties, freedom of the speech, freedom of the press, etc., you'll find almost nothing from the 1800s. There's a few from the World War I era, the early 20th century, because there were some really very repressive laws passed at that time, and some of them ended up before the U.S. Supreme Court. People were worried about anti-war sympathizers around World War I, and some laws were passed to criminalize their activities. A lot of that went to the Supreme Court, and some of them were struck down. But you will find that almost all civil liberties jurisprudence comes from 1938 to the present. You will find that the real golden era of expanding our civil liberties and our civil rights is the Warren Court, the court where Earl Warren was the Chief Justice, 1953 to 1969. That was the great golden age of civil rights and liberties. The Berger, Rehnquist, and Roberts courts have predominantly Republican courts, and they have maintained most of the original civil liberties jurisprudence, but have cut back on it. A number of areas like the rights of the accused in criminal cases and a number of other things. And the Roberts Court has actually expanded certain specific civil liberties, particularly the Second Amendment. That is the right to keep and bear arms. They have greatly expanded that. And you could expect that to continue. And they have also expanded, as we just saw, religious liberty claims, where people asserted the right, the civil liberty, the freedom, to be exempt from anti-discrimination laws. In other words, they're saying my religion, like the baker, my religion gives me the right to discriminate against people. And this Supreme Court under Roberts has been sympathetic to those claims, as we just saw. Now, I don't expect you to remember all of this, but just understand, when I said 1938, there's a reason I said 1938 is when the U.S. Supreme Court suddenly got interested in civil liberties and civil rights, and it comes from a particular case, and it's called Footnote 4. It's very famous. When you get to law school, if you do, you'll learn all about Footnote 4, in a case called U.S. versus Caroline Products Company. But basically, I don't expect you to memorize it, but just understand, they said in this opinion that they were going to, that the Supreme Court going forward was going to be much more careful, a much higher level of scrutiny of any law that violated basic civil liberties. This is something that they decided to do in that case. And so this is what led ultimately to there being different standards of scrutiny of different types of laws. In many laws, like if you challenged in court a parking regulation of the city of Chicago, you said, they say I have to get a parking permit to park on the street. I don't think I should have to buy a parking permit. I should be able to park on the street. That would be judged by a very low standard. It would be very easy for the city of Chicago to win that case, because all they have to show is that it's rational. They just have to show that it's a rationally related to some government interest. And they'd say, well, we're just, trying to make sure that residents have a place to park, so we require them to get permits. And the court's going to go, well, okay. That's a very low standard. It's called the rational basis test. Is this a rational law? Yeah, it's rational. Is it the best way? It doesn't have to be. But if a law violates a fundamental right, freedom of speech, freedom of press, etc., or if it restricts the political processes, if it infringes on your right to vote, things of that sort, if it involves attacks on a statute, particular religious or national or racial minorities, you see those three things that are in the footnote? If it does that, then the stakes go up. Then the burden on the government goes way up to something that we call strict scrutiny. And suddenly the government has to show that what they want to do is necessary to further a compelling state interest, not just rationally related to any legitimate government objective. If they do one of these things, then this is what we call, it gets strict scrutiny. It gets looked at very closely by the court, and it's almost always the case that the statute is struck down. Almost all statutes that are subjected to strict scrutiny are declared unconstitutional because this is a very high standard. So now, let's talk a bit again about incorporation. I may be repeating myself, but understand. The Supreme Court had different alternatives. They could have said, well, we're just going to incorporate the entire Bill of Rights into the Due Process Clause all at once. But they never did that all at once. Instead, they did something called selective incorporation, case by case. And it has taken like 100 years to incorporate basic provisions of the Bill of Rights into the 14th Amendment Due Process Clause, so they limit the states. So let's look at which ones they are. The First Amendment is fully incorporated. States have to completely respect the First Amendment, just like the federal government does. Second Amendment, totally incorporated. Third Amendment, which is about quartering troops in your home, well, Supreme Court hasn't ruled on that yet. And everything else really has been incorporated except the Seventh Amendment, which is the right to jury trial in civil cases. In a federal court, if you have a civil case, one person suing another for money, you have a right to a jury trial. States don't have to respect that. So if a state does not want to give us jury trials in civil cases, they don't have to. But everything else basically is the same. Almost everything. You can read it and see, but there's some little differences with respect to the Eighth Amendment, but understand almost the entire Bill of Rights now applies to the states as well as the national government. And there also are state bills of rights, and those can be, every state constitution has a Bill of Rights, and so those sometimes have slightly more expansive terms, even more protective of our rights than the national government is. Now, this is that thing I was just telling you, strict scrutiny and rational basis. Here it is in writing so you can understand it. If a law infringes on a fundamental liberty, like, for example, a law that discriminates against people based upon race or religion, or violates freedom of speech, tells you can't give a speech in the public square, it has to be justified as being necessary. What they are doing, the limitation has to be necessary to a compelling state interest. But an ordinary piece of government legislation that does not impinge on protected rights or liberties, all it has to be is any rational relationship to any legitimate government interest is fine. Now, there's a little bit of a middle ground. Gender discrimination and discrimination against children whose parents were not married at the time the child was born, those go in an area of intermediate scrutiny where the law has to be substantially related to an important government interest. So it's in between, but there's very little. Almost everything is either under strict scrutiny or the rational basis test. And understand, if the government almost always wins if a law is challenged under the rational basis test, the government generally loses if it's subject to strict scrutiny. So let's go through these liberties. Again, here we are. First 8 amendments. And I want to emphasize 9 and 10 just once so you understand. The 9th Amendment says there might be other rights and liberties that they didn't get mentioned in the first 8. But it doesn't specify what they are. It just says there could very well be others. And don't assume just because we haven't listed them all that there aren't others. The 10th Amendment is the one, we talked about that when we covered the Constitution. It gives states the reserved powers And it says, essentially that the national government is a government of expressly delegated powers, and the state governments have all the other powers. They don't have to find them in the Constitution. But for our purposes now, civil liberties, the First Amendment is the main source of civil liberties claims, most of them. And the Fifth Amendment takings clause has recently been expanded as by conservative justices and conservative think tanks and law firms. The logic of civil liberties is that there's a private sphere and a public sphere. The private sphere is the realm that is supposed to be beyond the reach of government, and the public sphere is the area where government can regulate our activities. And that's the way it's looked at. And the logic of it was, it was grounded in religion originally, that they believed in God. They would say God gives us life and we have the right to protect it. We create property, but by mingling our labor that we own with nature that was given to us by God. Again, I'm just stating it the way Locke did, which creates private property as a natural right in their view. And then the argument is, well, we have the right to protect our lives and ourselves and our homes, and these are, quote, God-given rights. We have the right to private property, which is basically a God-given right. And then we create governments to make it easy for us to protect our property and ourselves. And so the government has no right to intrude upon this realm of liberty. It is created to protect this realm of liberty. And if a government does infringe on our fundamental liberties, it's illegitimate. That is the logic of civil liberties as given to us by philosopher John Locke. So, when we look at the essential parts of the First Amendment, the whole text is right here. Congress shall make no law respecting an establishment of religion, which refers to government promoting religions. And we're not supposed to do that in our system. That's where we come up with this idea of a wall of separation between church and state. That comes out of the this is called the Establishment Clause. No government promotion of religion. Or prohibiting the free exercise of religion. So government can't promote religion, but it also can't prevent us from practicing our religion if we want to. Government can't abridge the freedom of speech, can't abridge the freedom of the press, or the right to assemble and petition the government for redress of grievances. That latter part about assembly and petition, that is sometimes referred to as freedom of association. But basically it protects such things as political demonstrations, lobbying, communicating with government officials, etc. And that's the core of civil liberties, with one more exception, and that is the Fifth Amendment Takings Clause. It says in the Fifth Amendment, nor shall private property be taken for public use without just compensation. Back in England, that happened all the time. If the king wanted your property, they could take it. And they didn't even have to compensate you for it if they didn't want to. Not in the U.S. So this is a fundamental protection of the right of private property against government taking it because they want it. So just to show you the logic, here's an example. This is the logic of civil liberties. In a case of West Virginia State Board of Education versus Barnette, 1943, a Jehovah's Witness refused to do the Pledge of Allegiance, the flag salute, in school. Why? Well, their religious beliefs said they should not do it, but it was a state law at that time that all students had to salute the flag. Now, so actually the Supreme Court, only 3 years earlier, in a case called Minersville School District versus Cubitus, 1940, the Supreme Court had said they can make you say the Pledge of Allegiance in schools. But they reversed themselves 3 years later, and they said the following: the purpose of the Bill of Rights was to withdraw certain subjects from political controversy, to place them beyond the reach of majorities. You see the logic of it? Certain things about our private lives, such as our religious beliefs, are beyond the reach of government. They are in the private realm. That's what Justice Jackson was saying. Now, what that means is that the Supreme Court has said that no one can force you to say the Pledge of Allegiance in a classroom. And yet, I would be willing to bet that there's some people listening to this who were forced or who have seen people forced to do just that. To say the Pledge of Allegiance. And I know that my own kids, when they were in school, they were pressured to do that too. Everyone, I mean, not them particularly, but students were pressured to do that. But it is actually unconstitutional. No one can make you say the Pledge of Allegiance. It is a constitutional right that it's a freedom of your conscience to say it or not say it. Now, interestingly, though, it wasn't religion that came first. The first civil liberty that was recognized by the U.S. Supreme Court is the right to private property. It was the Takings Clause. And I think that's kind of interesting. Property really came first. Now, the first time it was tried was 1833, and it was unsuccessful. As I said, Barron versus Baltimore. This Mr. Barron sued the city of Baltimore for wrecking his business. He had a wharf, where boats dock. He had basically a dock. And due to construction work going on in the city of Baltimore, they dumped a bunch of dirt into the harbor, and it ruined his wharf. It silted up the harbor, and the ships couldn't get to it anymore, and they ruined it. So he said, well, all right, I'm suing the city of Baltimore under the Fifth Amendment. But you see the problem, right? The Fifth Amendment originally, before the 14th Amendment was passed, and the Supreme Court said the Fifth Amendment only limits the national government. And so in 1833, could a state government literally take your property and all its value from you, which is what they did to him, essentially? No, the answer was yes, they could, because the Fifth Amendment Takings Clause did not limit the states. But now it does, because the 14th Amendment was passed in 1868, and eventually the Supreme Court reversed itself. 1897, Chicago, Burlington, and Quincy Railroad versus the City of Chicago. Where the Supreme Court said compensation for private property taken for public use is an essential element of due process of law as ordained by the 14th Amendment. And right now you should understand this, right? And I think by now you understand what that means. The Takings Clause of the Fifth Amendment was incorporated into the 14th Amendment Due Process Clause, and it limited the city of Chicago. Now, again, these are the basic rights, and I'm going to go over some of the substance now of each of these civil liberties. I used the term rights. I should have said liberties. First Amendment, right? Let's take religion first. Two clauses, the Free Exercise Clause and the Establishment Clause. The Establishment Clause, let's take that first. Leading case is Lemon versus Kurtzman. It says, now how do we know whether the government is promoting religion or not in violation of the Establishment Clause? The government, the idea here is that England had, quote, an established church. Many countries used to have what are called established religions, like the Church of England, an official government church. Well, the U.S. can never have that. And so whenever you hear people claim that Christianity is the official U.S. religion or whatever they say, that's nonsense. We don't have an official religion. It's right there in the Constitution that we can't have a government religion. We cannot have that. So when people claim that this is a Christian nation and all that stuff, that's all nonsense. That's just constitutional nonsense. You're welcome to. Anyone is welcome to practice their religion, whether it be Christianity or Islam or Judaism or whatever it might, any religion. You can certainly, because of the Free Exercise Clause, you can practice it. But no religion or group of religions can be the official religion of this country. That's what the Establishment Clause says. And it says, it's been itemized as follows. There are three parts to seeing whether this has been violated. One, you look at the law. Was the primary purpose of the law secular or religious? Secondly, what's the primary effect? Does the law advance or inhibit religion, or is it neutral? And thirdly, does the law excessively entangle the government with religion? And that is the test that we use. These are the kinds of questions you ask. The court would ask to see if a law violates the Establishment Clause. Ideally, laws have a secular, in other words, non-religious purpose. They do not advance or inhibit religion, and they do not entangle the government with religion. If it goes the other way, if we have laws passed that have a religious purpose, that's a problem. If they advance religion, or even they could inhibit religion, but usually the problem here is advancing religion, that's a problem. Promoting religion. And if they entangle the government agencies with religions, to their finances, their accounting, their bookkeeping, that's a problem too. And so that's the Establishment Clause. The Free Exercise Clause, look, you can believe anything you want. The freedom to believe is absolute. But the freedom to act in accordance with your beliefs is sometimes subject to regulation. The basic standard is the government, remember, because of strict scrutiny, the government needs to have a compelling interest if they're going to burden a religious practice. Now, this is a tough one. This is a very tough one to sort out. The Supreme Court has had many cases on this. They have allowed, for example, the Amish people to use horse-drawn carriages on public highways, which would normally be illegal for everyone else, but the Amish had an exception. They've allowed them to keep their children out of school much longer. I mean, normally, we're all required to go to school, public or private, up to a certain age, 16 or 17, depending on the state. But the Amish are usually exempt from that because it would destroy, the argument is it would destroy their culture if their children had to go to school. And so there are some exceptions, but other practices like slaughtering of animals and pursuant to religion, having multiple spouses, this has been held illegal. Laws against bigamy, etc., can be enforced, and many other. But understand, this is an area where there's a lot of dispute on the Supreme Court, and so the law is not 100% clear on how to, in particular cases, how it's going to be applied. But as a general rule, the freedom to believe, you can believe whatever you want, but when you act, if you're violating criminal statutes and neglecting your children, leading them to get sick or injured or not medical treatment when they need it, that's a different story. Then there can be real regulations. Now, when the really interesting question, what if the government cannot establish a religion, treat a religion like it's official, at what point does that infringe on the individual's freedom to practice religion? So, for example, let's say that you are in a high school, public high school, and you want to have a meeting of people after school, like a club, and it's going to be for, let's say, for Christian students or Hindu students or whatever, a particular religious group. And you go and you ask for permission to use that room. And the principal says, well, I'm sorry, we can't do that because if we did that, we would be establishing a religion. We'd violate the Establishment Clause. And you might say, well, wait a minute. If you let other people use these rooms for their clubs, you're saying we can't use a room because ours is a religious organization? Aren't you infringing on our free exercise of our religion? So you see, these things can sometimes be difficult, and that's why a lot of these cases end up going to the Supreme Court, because you end up with different types of claims conflicting with each other. Now let's take freedom of speech. Speech is presumed to be constitutionally protected. Normally, that's the rule. It's protected. However, certain types of speech are carved out of that protection. They don't get any protection. One, obscenity. Obscenity, that means, and I'll tell you what that means in just a minute, but it means it is sexually oriented material that goes beyond certain standards. Fighting words and libel, challenging people to fight, libeling them, defaming them, not protected. Incitement to imminent lawless conduct, not protected. Let's go, if you say something like, let's go commit a crime, let's go storm City Hall, these sort of things, the sort of things that happened on January 6th, let's go lynch, the vice president, these things that these Trump supporters were doing on January 6th in the attack on the Capitol. And those things can be carved out as incitement to imminent lawless conduct, no protection. And there can also be reasonable time, place, and manner restrictions on our speech, so that, for example, even though we are at a state institution, or state action, we have to protect people's First Amendment rights. We can have limitations on where you can exercise your freedom of speech, like in a classroom. Classrooms are not free speech zones. We have free speech zones out in the Quad and elsewhere, but when you have government property that is dedicated to a certain purpose, such as in our case learning, we can enforce that. So professors can say, okay, we're done talking about that now. And if a student says, no, I want to continue talking, I have First Amendment rights, the answer is, yes, you do. But we have a reasonable time, place, and manner restrictions, and you can't do that here right now. You can do it elsewhere at a different time. And so that also deals with regulations with private property. Now let's talk just a bit about obscenity. There used to be a lot of prosecutions for violations of this of obscenity statutes. And the Supreme Court ultimately came up with a standard. It's called Miller versus California, where they said what we mean when we say something is obscene and therefore can be criminalized is whether the average person applying contemporary community standards would find the work appeals to, quote, a prurient interest in sex. If you can figure out what prurient interest means, good luck to you. I don't think anyone really fully understands what that means. But I think the gist of it has always been it is overtly sexual. It is intended to be sexual in nature. But secondly, it also has to be patently offensive. Patently means obviously. And third, it has to lack serious literary, artistic, political, or scientific value. Now, this is interesting. You will find that almost nothing is currently being prosecuted under existing obscenity laws. There are very few obscenity prosecutions. There used to be a lot of them. But eventually prosecutors learned that starting in the 60s and 70s, juries would not find things obscene like they used to. And as a result, the only kinds of things that usually get prosecuted for obscenity are things involving child pornography and that sort of thing. That is clearly obscene. Juries will definitely convict people of that. And it violates very specific laws as well having to do with the sexual exploitation of children. But most of the traditional things like the book Fanny Hill, James Joyce's Ulysses, real literary works, were subject to obscenity prosecutions way back in the 50s and 60s, and that almost never happens anymore because of the new standards under Miller versus California. Freedom of the press. Now, some of this we actually talked about a little bit, but key rules. One, the freedom of the press means, above all else, no prior restraints on publication. There might be punishment for publishing certain things if it was stolen or if it's libelous or whatever, but blocking publication almost never allowed. No prior restraint on publication. Secondly, New York Times versus Sullivan. Public figures like celebrities and politicians have a very hard time winning libel suits against them. They say, well, you said something terrible about me, like Donald Trump or Barack Obama or some president or public figure saying, you said terrible things about me in the press. Well, you know what? That's probably not going to result in a win. If Barack Obama or Donald Trump or somebody, any public figure, sues a New York Times or NBC or whoever for libeling or defaming them, they will probably lose. The media defendants will win almost every time because there's a very high standard for public figures. They have to show actual malice, meaning knowledge that the statements were false. Well, how often do you think NBC or something or the New York Times is going to publish something that they absolutely know is false? And the answer is almost never. That almost never happens. National Enquirer, maybe. Major media outlets, nope. And the other way you could win is to show reckless disregard for the truth, where they didn't even try to find out if it was true or not. Again, that almost never happens. So it's very hard as a public figure in the U.S. to successfully sue a media defendant. However, there are some limits to freedom of the press. Julian Assange, who you may have heard of, used WikiLeaks to publish material that was actually stolen from U.S. government databases and other communications channels. And this can lead to prosecution. And so Julian Assange and other people who actually publish stolen material, they may be able to publish, but they can be punished after the fact for it. Freedom of association. Well, I mentioned the right to assemble and petition government. Well, it also protects your liberty to associate with your family, to join organizations where you express your beliefs, and where it sometimes creates problems is where people join a private organization that wants to engage in some form of discrimination, such as racial discrimination. That can be a real problem, and these are the kinds of cases that end up in front of the Supreme Court. Now, really an incredibly important one, the right to privacy, and I want to spend just a moment on that. It's just a couple more slides, but let's spend a moment on this one. The so-called right of privacy is really a liberty. It's an area that the government is supposed to leave alone. And it was discovered, so to speak, in 1965 in the case of Griswold versus Connecticut, which dealt with a ban on birth control that was effected by the state of Connecticut. And it became the foundation for abortion rights in Roe versus Wade. Now, many Republicans and conservatives, including some people in the U.S. Supreme Court, claim there is no right to privacy. If in the event that Roe versus Wade or other decisions are questioned before the Supreme Court, this whole issue can come up, the existence of a right to privacy. However, it has been since 1965, the Supreme Court has said that the Constitution protects a fundamental right of privacy. However, it is not completely clear 100% what is in that right. We know it includes right to access birth control and the right to obtain abortions. Now, last slide here. We're not going to spend a lot of time on this, but the rights and liberties of the accused are also protected by the Bill of Rights, primarily in the 4th, 5th, 6th, and 8th Amendments. The 4th Amendment protects us against unlawful search and seizure, which is a privacy right. There's a rule called the exclusionary rule. The Supreme Court has said the states must respect, which means that if evidence is seized from you in violation of your constitutional rights, it can't be used against you. And that Weeks versus U.S. For federal prosecutions, and Matt versus Ohio for state prosecutions. The 5th Amendment, freedom against self-incrimination, protection against double jeopardy. The 6th Amendment, speedy and public trial, etc. And the 8th Amendment protects us against cruel and unusual punishment. And the question then is, what is cruel and unusual punishment? The issue that comes up again and again is whether the death penalty is cruel and unusual punishment, or whether particular methods of execution are cruel and unusual punishment. But these are the rights and liberties of the accused. We're not going to, there's more to this. This is a big subject. And I teach a course on the judicial process, which we talk a lot about this. And then we also have a whole department that does nothing but teach people about how the criminal justice system works. And so we have lots of opportunities to learn more about this. But that concludes our first of 2 videos on civil rights and liberties.